All right, continuing on with the pretrial conference statement. In another video, we went over the stipulations page. Now we're going over the issues page. So you're at the mandatory settlement conference. You cannot come to an agreement with the defense attorney or the insurance company, and you're setting the case for trial. It is the issues page which lays out for the trial judge what he or she needs to be looking at. Let's look through that page now. The first box is employment. So if you have a dispute as to whether or not you were employed by that employer on the date in question, employment will be checked. Oftentimes that doesn't go to trial because it's able to be resolved informally by the parties. Either you have paycheck stubs or you don't. So employment often doesn't go to trial as that can settle beforehand, but it can happen. Insurance coverage. If there is a dispute as to whether or not a carrier has coverage for the employer on the date in question. And then getting into the more common areas, injury arising out of and in the course of employment. So you allege that you were hurt at work and the employer has denied the claim completely, either saying that your problems are pre-existing or that your injury occurred off of work, or maybe that when your injury occurred you were not on the clock, or maybe were off the employer's premises. But injury, AOE, COE, did it arise out of your employment and did it occur in the course of your employment? That would be checked. The parts of body injured line. So if the insurance company has accepted certain body parts, those don't get listed here. This is for the trial judge to address whether or not there was an injury to these specific parts of the body. So maybe the insurance company accepted a few parts of the body but denied others. It is those denied body parts that will go here. If the case is denied entirely, then all of the body parts that you, as an unrepresented injured worker, are alleging were injured, those will all get listed as parts of body at issue. Earnings, you may have had an agreement with the defense attorney on the stipulations page as to your average weekly wage. If you didn't and there is a dispute, then you need to list here what you claim your average weekly wage is, and you'll need to back that up with evidence. You're going to need to list what it's based upon, and then when we get to the exhibit and witness page, you're going to have to list your documentary evidence to support why you claim that specific average weekly wage. Next is temporary disability. If you were taken off work by your doctor, or perhaps you missed time from work due to your injury, but you were not paid temporary disability, that time period is going to get listed here. That way the trial judge knows he or she needs to look at past medical reporting and listen to your testimony on that point as to why you were off work and whether or not there is liability for that retroactive temporary disability. One issue that I would see as a trial judge is that injured workers, when they didn't have an attorney, would check the box on the stipulations page saying that they had been adequately represented or adequately paid for all temporary disability. And then when we got to trial, they would say, but judge, I also need to get paid for the temporary disability because they didn't really pay me everything that they owed. That's a problem. If you've already stipulated that you've been fully paid and that you didn't list it here, it's a problem for the trial judge because the defendant needs notice, and it's going to be a problem for the injured worker, for you, because you didn't put the parties on notice that this is an issue. So if there's an issue with retroactive temporary disability, it needs to be listed as an issue. Permanent and stationary date, oftentimes the parties can agree on this. It will be based on what the qualified medical examiners found, maybe what the primary treating physician found. If there's a dispute, you can list what you believe the correct date to be. Permanent disability and apportionment. It's the area where I saw the most trials with pro-per injured workers because injured workers would dispute what the qualified medical examiner found. They felt that the permanent disability was simply too low for the injury that the injured worker had incurred. So if you feel that permanent disability is too low, or the apportionment to non-industrial issues is too high, if that's where your dispute with the insurance company is centered, those boxes need to be checked. Occupational group and group number. Those are areas that it's tough for an injured worker without knowledge as to the different occupational groups to really make an informed estimate or decision as to what the correct occupational group is. You may in that situation want to rely on assistance from the Information and Assistance Officer. You may want to rely on what the Disability Evaluation Unit rater used for your correct occupational group, or you may simply list it as an issue and then write that you are unsure as to what code you believe it should be, and you can introduce testimony or documentary evidence to the trial judge to help the judge make that decision. The need for further medical treatment, that box is most of the time checked because your condition may be permanent and stationary, but you still need ongoing medical treatment, so that box often is checked. Liability for self-procured medical treatment. If you paid a doctor out of pocket for treatment before the case was accepted, let's say, then in those instances you need to check that box so that you can have the trial judge determine whether or not you should be reimbursed by the insurance company for those out-of-pocket expenses. And again, once we get to the exhibits page, you're going to need to list exhibits to back up your assertion. Liens. Generally, if you are a pro per injured worker, you're taking your case in chief to trial, there generally are only two liens that may be at issue at trial. One would be the Employment Development Department, because if you were off work and they paid benefits, depending on what the trial judge finds, they may be entitled to reimbursement from those benefits. The second potential lien would be if you had an attorney in the past, but you do not at this time. If that attorney filed a lien for attorney's fees, that lien may be addressed as well if the trial judge is going to be addressing permanent disability. Generally, all other medical treatment liens will be deferred until a later date, so the case in chief can be addressed at this point. Attorney's fees, again, only gets checked if you have an attorney or if you had an attorney in the past. If you're an unrepresented injured worker now, you may have had an attorney previously. Check that box to make sure that the prior attorney is taken care of if a lien was filed. And then other issues. Sometimes the dispute between an injured worker and the insurance company is not neatly defined in one of the boxes up above. So if that happens, write out the issue that you have. If you have a dispute with the insurance company and you want the trial judge to know it, write it out in the issues line there. It's not necessarily something that both sides need to agree on. So it's different than the stipulations page where both sides need to agree on what the stipulations are. Here, you are listing what you believe the issues to be. So if you don't believe that the QME report is correct, you can list as an issue that you dispute the QME report or that the QME report is not substantial evidence. If the defense attorney lists an issue that you don't believe should go to trial, then you can list your issue there as objecting to the defense attorney's issue that was raised. Generally, the settlement conference judge will review that at the settlement conference and make a determination as to whether those issues will go to trial or not. What the conference judge may do is defer that issue to the trial judge. So still be prepared to address it when it goes to trial, but the trial judge may parse out some of those issues. That takes care of the issues page. In a separate video, we'll go over the exhibits and the witnesses page because you're going to need to use this issues page to outline what exhibits you're going to file. You always want to make sure that your exhibits support all of the issues that you raised. Catch that in another video.